Rich Edson there in D.C. We're going to go to Marc Fernich now, who's here with me in the studio, an attorney for some more on the legal side of all this, criminal defense attorney by trade. Good to see you, Marc, and thank you for coming in.
Thanks for having me
this morning. We appreciate it. Now, just sometimes people always wonder, where are people coming from politically, because often that shapes where they are. You voted, I believe, for John McCain last time around, am I right?
I did.
And you plan to vote for Mitt Romney in the fall.
Yes, I do.
The reason I bring that up is because all of that said, you agreed with the ruling.
I do agree with the ruling, and here's why. It's not the court's job to pass on a law's wisdom as policy. That's for the representative branches. That's why we elect presidents. That's why we elect congresspeople.
That's what John Roberts said yesterday in his writing, which made it interesting to me that the argument from many conservatives, and I've heard it on the air, I've seen it in writing, is that this was an activist decision by the court.
That's just a conservative talking point, and obviously they're going to say that Roberts rewrote the law. But what they profess to want in judicial nominees is judicial restraint and deference to the legislative branch. And consistent with that, it's basic constitutional law that it's the court's duty to construe a law as constitutional if that's a fair and reasonably possible reading. And that's what Roberts did. He gave them exactly what they professed to want.
But why do you think somebody like Anthony Kennedy was so adamant and aggressive on the other side?
Because Kennedy is a more activist and result-oriented judge than Roberts was in this particular case. Roberts obviously had to be very concerned about the court's legacy and its institutional credibility. I'm sure that Roberts personally detests this law, but he respects the institution of the Supreme Court. That institution must be publicly respected, and he put politics aside for the betterment of the court.
There have been political criticisms of the Supreme Court dating back really to 2000 and the Bush
v. Gore, Citizens versus United.
So some
Citizens
people,
United.
exactly, Citizens United. And then people look at this and say, maybe the Chief Justice heard some of that.
He did.
And he wanted to make sure that the court, but the criticism this time is that he gave into that and said to himself, well, and now people are starting these, I don't know if they're rumors, I mean, maybe more speculation, that he changed his mind on this and didn't want to open himself up to political criticism.
I suspect he did change his mind, but that's his prerogative to change his mind.
You're okay with that?
Totally okay with it, because he respected basic tenets of constitutional law. Again, the foundational principle here is that a court is supposed to uphold the constitutionality of a law if that's at all possible. To invalidate a law as unconstitutional is the judicial equivalent of a nuclear weapon. It's rarely supposed to happen, and it properly didn't happen in this case.
And what about the ruling on the Commerce Clause part of it? Because conservatives will point to that and say, hey, thank goodness that it wasn't upheld on the basis of the Commerce Clause, they're saying to themselves, because that would have been, quote unquote, worse. What do you say?
Well, I think he found the law anathema as a Commerce Clause matter, and he protected his view of the Commerce Clause for the conservatives. But I also think that he wrote that opinion on the Commerce Clause to try to get some of the conservatives over to his side, particularly Kennedy, and it didn't work.
So, to explain that a little bit, Congress has the ability to regulate,
but it doesn't
commerce,
have the
not
ability
to compel it.
And it also doesn't have the ability to use commerce as essentially a police power to force people to do something. And this has been a running debate since at least 1995 with Lopez. So this is not new. Did you start in your head, or maybe this morning start to think, what is this going to lead to? What other cases might we see brought because of what was ruled on yesterday? I think it's what we call in the law sui generis, which is a fancy word for unique. I don't think it will have that much precedential impact overall, except with respect to the Commerce Clause, which is a recurring issue in my practice, and that's criminal defense, because Congress typically uses the commerce power to aggressively regulate purported criminal conduct, and that's a hot-button issue.
Won't be able to do that as much, you don't think, because of this. All right.
Yeah, push and pull.
Thank you, Marc.
Thank you very much for having me.
Attorney Marc Fernich with us today. And